Oops. Hello. Good afternoon. No one's here. but, so hello, good morning, good evening, where whenever people are going to watch this. Um I got the news last night. I've been helping my friend babysit, and so babysitting, working out right after, waking up at like 6:30 a.m. It's been an adjustment, let's say. I'm determined to still work out as much as I can. Not as much as like physically possible, but as much as I like, less than that, like I'm not wearing myself out completely. But yeah, anyways. So I got this notification. I think it was on Instagram, and I saw Lauren's not TikTok, oh my gosh, reel that wow, excuse me, I had coffee. That the judge ruled, basically dismissing a lot of Blake Lively's case against Justin. Um, Only three claims remain. So I saw that, and I looked at Elsie's video. I was just right now. It's still I'm still well. No, I guess not. No, yeah. I paused Brianna Eves live. She's live reading the whole thing. Um, Wait, let me keep going, support her, but at the same time, do my thing too. And some news channels reporting on it. And I will start off by saying this from what I understand at this point, before reading myself any of the order. And I'm not even saying that I will understand a lot of it. Maybe I will, maybe I won't. From everyone's like conversations, the judge ruled yes on a technicality. Technically, she doesn't have a legal, like, technical case against Justin Baldoni for harassment or retaliation on that. Pui, pui, pui. Because she was not an employee. That's basically the gist of what I'm saying. And as one of the news stations, I forget which one, I think NBC News, uh, and also TMZ was saying, and this is from my understanding correct, um, it is not a rule on the merit of her claims. So it doesn't mean that he said there was no harassment. It's just him, the Judge Lyman, saying it's a moot point for the court. Like it's not a valid claim based on the circumstances that but that's a summary. But what I was seeing on Ashley Brianna Eve talking or reading through the order, um I from my understanding is he's kind of saying like she had power on the set. So that's why there is no validity legally for legal action, because it's not that she didn't have power. That's part of like the claim or part of his ruling. So we'll get into it, or I'll get into it. I'll read myself through this. I haven't read through things in a while. I haven't been part of this in a while. I'm also going to like get off of, well, I can't really exactly get, well, I will, as I'm reading the court case, get off of this because I would get distracted by like the counter not being up. For some reason it is kind of weird to talk in the void. That's why I do more lives than videos, because it's nice when there's people to interact with, and I see people, here, and seeing the zero, or now there's like one person, hello, the one person. And then when people like, because I know some people browse off, that ends up showing as the counter is zero. So I'm like, I get distracted. So I'm gonna just focus on reading the order, judge's order. But before so to reiterate, the news right now, Justin Baldoni seems to be completely out of it. Technically, no, because he is part of It Ends With Us LLC. I believe, he's part of, because he's a producer. He's part of Wayfarer. I mean, that's he's like third, 1/4 of Wayfair, as a founding member. So he's not out, like, in terms of he's still going to have to deal, with the lawsuit part of things, but as a person, he's out as a defendant. So really cool. Um, but I also want to keep in mind and address that the news is saying, yeah, but technically, because this will like be Blake Lively's angle, I'm sure. It's like, yeah, the judge ruled on technicalities, but he didn't say that I wasn't assuaged, that I wasn't harassed. That's probably the angle they're going to go for. So we'll see. We'll see if anything counters that and what the judge says. Um, but yeah. Oh, and then right before I came on, Ashley Brianna Eve, she was reading that Blake is unable to seek damages for her businesses, the hair care, the drink line, et cetera, because of this, because basically she kind of did that for herself. So huge win on that. I think that's a really big win. Big win. Not just because of money, but because if I understood it right, and I'll get to it, I think that was like page, I don't know what page she's on, 73. Okay. Um, I- yeah, I we'll see. Anyways, but I think that's a huge win. Also her lawyer, Blake's lawyer, allegedly is telling NBC News that, quote, her lawyer, Blake's, tells NBC News she's looking forward to testifying as far as the harassment. So the harassment claims are still on, but for not Justin, but for Wayfair. I think, right? Not harassment. Sorry. The retaliation. Um, and it's retaliation based on like Fair Workers Act something. um, yeah. So, ooh, that's I'm curious. Sorry, not to like take away. So please go support any video that I show you. And I really like that. I feel the community that shows up for our videos, for my videos especially, because I'm not that popular as anyone else, mainly because I kind of fell off the face of the YouTube earth on this case. It was just like a lot. But you will go actually rewatch people's videos. One, because we're kind of curious and we at one point are like, oh, we want to see more angles of this and other people talking about it. But also I think there's like a sentiment of community and helping each other out. So watch not actually Golden's full video yourself, but also let's watch it because I'm really curious. She just posted this. Well, uh less than an hour ago. It says so much misinformation going around. So I'm very curious what she's about to say about this.
Seems I'm going to need to make a standalone TikTok on this issue because this is the misinformation that's going around so much already. And I've talked about it before, but I think it bears having its own video so you can refer to it. This issue of the reason why Lively is not covered by Title VII is because she's an independent contractor, and doesn't that leave independent contractors without protection? Okay. The termination laws is the uneven power dynamic between employers and employees, right? Employees need the job and employers control the job environment. And so the reason why the term is hostile work environment is because the laws are intended to say if the employer creates an environment that is so discriminatory that it makes the employees not able to do what they were hired to do, That's a violation of the law. The power dynamic has gotten way out of hand, and we need to bring the power dynamic, actually, it's probably more like this. We need to bring the power dynamic back to a reasonable place. The reason that independent contractors are not covered by federal discrimination laws is because independent contractors do not have that same power dynamic difference with employers. Independent contractors get to control the terms of their contract, when they come, who they work with, what environment they're in physically
I mean,
and
to sort of say, as someone who's done delivery with, food delivery, grocery delivery, and you are an independent contractor for that, and yes, you technically control of that. Not to give Blake, any credit, because again, like, I think she's just using laws, but it's not really real, in my opinion, allegedly. Um, what she's saying. But yeah, like, yeah, you do have a say in it, but you also are aware that you have to be reasonable. And if the employer or the company or the people that hire you for whatever you're an independent contractor for don't like your terms, so it's kind of like the same, but legally, yeah, it's different. And yeah, all I want to say is, like, you don't have that much choice, but technically, yes.
otherwise, when they can leave, they are not subject to hostile work environments because they create and control the work environment themselves. Because there is equal bargaining power between the independent contractor and the employer who is contracting with them. It's a fucking contract where both parties have equal power.
All right. So I thought she was going to go into, like, more than just one thing. Maybe it's coming as it happens. I saw this.
Wayfair has
This is a great little, I don't know if this is from, where is this from? Wonder if it's from I don't know where this is from. Docket updates maybe. Um But this kind of shows, like, a glance, a very quick summary glance at basically what's out and what's still in. I had to look up, everyone's talking about FEHA, like we know what it is. I didn't know. I'm like, okay, I'm either really out of it with this case and people already explained it and covered, and the abbreviation has been covered, or I'm just not that aware of laws of things in general. So it's the California Fair Employment and Housing Act, which prohibits discrimination. This is based on Google's AI overview. Prohibits discrimination, harassment, and retaliation in employment and housing based on protected characteristics like race, religion, sex, disability, and age, meaning 40 plus. It applies to California employers with 5 or more employees and provides broad protections. I'm sorry, including mandatory reasonable accommodations for disabilities. So, employment protections under it include hiring, firing, promotion, and compensation. It prohibits discrimination based on orientation, gender, identity, marital status, and medical conditions. There's also a harassment prevention. It prohibits that in all places, even those with fewer than 5 employees, which is interesting because FEHA retaliation is in. But if she was, from like all the places that I've heard, if she was deemed to not have been an employee technically and an independent contractor, I want to know more why that's the retaliation is still on. Maybe it's like in the details, and also aiding and abetting the retaliation. It's interesting that Abel and Nathan are out and Tag is in. Like, that is kind of like, I don't know, that's interesting to me. because that's interesting. I don't know. I started watching The Lincoln Lawyer a few weeks ago. I already finished it, and I'm sad that there's not a new season. It's really good, and I think, and so made me think of this stuff a bit differently, or see it just like, oh my gosh, the launch. Did everyone see the launch? It's not the most exciting. We're not landing on the moon. We're not creating a base on the moon yet. That's like in 2028 is when they're planning for that, which is, I mean, that's like around the corner. If we're in 2026. But yeah, shows like Lincoln Lawyer, which, yeah, they're drama and this and that, and in this case, like, yeah, it's exciting because it's not that boring. It's people, it's celebrities we know, and you get into it, and it's also, it gets personal about when you've been wrong, when you've been wrongly accused, all of these things. um but yeah, like shows like Lincoln Lawyer, Suits. I stopped watching Suits LA right away. I don't know, that was a failure, in my opinion. um, I mean, Law and Order has been on for so many seasons. With Space for All Mankind, I keep saying that. Like, it's a really good show. It's not boring. It's drama. It's fiction. It's all of these things are fiction and drama and whatever, but they have this power to make you excited for real things. Because when I finished For All Mankind, I was like, ooh, like, what's happening in the space program? Where are we at? And can we get more funding? Can we actually make things happen? And then for like Lawyer, I remember watching Suits, and I didn't really want to, I didn't want to become a lawyer or like look into that, but I remember it changing my perspective on work. I was like, that's how I want to feel in the workplace. I want to be emotionally invested in my workplace. I want to be excited and driven, and be in a workplace where I am able to do that, where I have a purpose, where I can like work extra hours or whatever, and be so invested and passionate and, in it. Um so it changed my perspective of that. So yeah, anyways, that's a very like random tangent. But yeah, anyway, so let's see this one. So watch.
Won those
Yeah.
counts, and those counts are now over. To me, and 3 of them are still left in the case, and one of them only in sort of a halfway. Everything you see in red that says out, that means that the court has found, is going to enter judgment in Wayfarer's favor on that count, and that claim stops now. Wayfarer has won those counts, and those counts are now over. To me, the big headline that should be the headline, at least in celebrity and other media, is that every single one of the sexual harassment claims is now out. The idea of a jury finding that Justin Baldoni or Jamie Heath sexually harassed Blake Lively is no longer a possibility, because the claims for sexual harassment are gone.
And that is like, it is something that everyone's highlighting on YouTube. Um, but there is that like nuance, like it wasn't dictated, the merit of them weren't dictated, and so curious how that will, the narrative of it will. This is why, like, I'm curious, especially, is not just how the narrative will be spun around that for Blake Lively's side, but what does that mean for Justin's side too? Because just because he won in court, does he get the vindication and the relief, in the sense of, will people want to work with him? Will, I think Hollywood knows, I don't think Hollywood is discriminating against him based on Blake Lively's claims, but they could very much discriminate against the publicity that this whole case happen. So I know there's like a countersuit starting or happening or something too from him, from his side to Blake or to Stephanie Jones and things. Um, but yeah, like that's what I'm curious about. Like how much of a win do they really feel this is? Because we've been talking about and mostly I've seen this on Popcorn Planet's channel talking about, okay, like for this case to be dismissed, that's a big ask, or not dismissed, sorry, for an agreement to happen between the two parties. That's a big ask because oh Rosoro, hello. Because I don't know if you can see, I don't know what you can see. Um she's like getting ready to fall asleep on the phone next to me. And well, now she's she's doing that. But um what was I saying? Yeah, sorry. So this is another thing. I'm so sleep deprived that I don't even know what I'm saying. Um but yeah, so there's been a lot of talk around, well, for a settlement to happen, like how will that even look? Because his reputation, his livelihood, everything is kind of on the line. It's not enough to say, okay, we settled and this isn't going to court. He needs to win. And so, yes, this technically is a win as far as like the sexual harassment stuff being thrown out. But will it be enough for him to win? Someone was saying like neither of them will have their life back, basically. Like both of them will be in a way a pariah, more or less, for the industry. So like they have a lot to conquer in that sense for different reasons, kind of. Or I think the one common reason is, I mean, Justin didn't go to court because he wanted to, but like they went to court. They made this like whole thing, and they unveiled so much of the behind the scenes of what Hollywood needs to not be that apparent, because they need to control narratives all the time. Um, so yeah, but that's kind of my question right now. My wonderment, what I wonder about right now is, okay, yeah, technically this is a win. Uh, but like, is it really, and what is going to happen on that? I don't know if it was actually golden or some, not actually, sorry, not actually golden. I forget who was saying things, something around um what was it? I don't even know. I don't even know.
So that should be a huge takeaway, considering how much that has been the discussion of this case since the beginning. I don't know if people are going to try to spin it. I'm sure somebody will. I'm sure somebody will say, well, there's retaliation left and there's protected activity, blah, blah, whatever. We'll deal with that when we get there. But you can.
Yeah, I'm curious, and I almost want to like ask her. I don't know if my comment will be seen by her, but that's what I'm curious about is like this spin of, well, the merit of the sexual harassment claims has not been thrown out, or has it?
Feel comfortable. If I were in a room with Baldoni and Heath and they said, can I be found responsible or liable for sexual harassment? I would say no. That is now no longer possible. That is done. Okay. So the things that are left are essentially retaliation. There's the FEHA retaliation, which is the California law, the retaliation. The definitions of some of the things and the way that California law treats retaliation is broader than it is under federal law, under Title VII. And I'm going to need Little Girl Attorney to educate all of us, including me, on how that works, because I don't deal with that claim. I'm not a California lawyer. But that's why that one stayed in, because it looks like that covers more stuff than would otherwise be covered if it was just a Title VII claim. The aiding and abetting FEHA, which again is something they only have in California, where it's like, well, there was retaliation and you were helping. What the judge said was Abel and Nathan cannot possibly be personally liable for that, because even if they engaged in it, it was through their company tag. It wasn't them as individual people. And so those individual people are out, but tag stays in. That is important for Abel and Nathan because that means nobody can come after their personal assets if they were to go in front of a jury and lose. The other thing that is still in is the breach of the rider, which is the 17-point list. I thought the argument about there not being any consideration for it was solid, but I glanced over the judge's argument about why there is consideration, and I think he's right. So that one is still in. So breach of the 17-point agreement is still in. I would like to point out that just in a brief scan of this, even for the claims that the judge has left in, these 3 claims, in several of them, he notes, yeah, but we might need to narrow this before trial, or this might be appropriate for motions in limine about what damages can actually be recovered. So I don't think all of these 3 are actually going to go to trial just as they are. He just says, it's not appropriate for me to enter judgment. It's not appropriate for me to end the case right here. I'm going to let these go forward, and then we'll figure that out as we go.
All right. All right. Well, that was like, yeah, check her video out. That was a good sort of summary, and I really wanted not just like a lawyer to weigh in, but like someone who's as concise, and she lays it out in a way that's easy to understand, fast enough, and all that stuff. As much as I like doing lives, it is really hard to listen to lives when it's about like, I just want the freaking information fast and then dive into it. So I'll listen to her more, but that was a good one. Okay, so let me start reading this whole thing. Well, not the whole thing. We'll see. Okay, I'm stopping a bunch of these things because yeah. Oh, there's a conference today for lively counsel only, sorry, on docaupdates.com. So there's this conference today to discuss updated settlement positions. Here's what this is. And this is cool. Wow, this is a fun website, but not very helpful as far as that. Anyways, okay. So, all right. I am sure that like I'm not so needed here. That people have been reading this, covering this, and yeah, clearly I've seen in my last videos, clearly I am I've fallen down the ladder for sure, and I was never really high up, and that's my own doing because I haven't shown up. And on YouTube, if you don't show up, if you don't do content, you just get out of the algorithm, and also people forget. It's kind of like TV shows that wait forever for a new season. It's like, do I even want to bother watching at this point? Found like other ones to watch. But anyways, what is this update? Okay. I don't know why it was updating. Okay. So, Louis J. Lyman, United States District Judge, says on April 2nd, 2026, the court held a status conference in this matter today. The court discussed certain scheduling matters as indicated on the record at the conference. Oh, this is the wrong one. Sorry. I think what is it? This one? No. This one. So sorry about that. The loss grows out of events occurring during the production and promotion of the Hollywood film It Ends With Us and the very public fallout between its two co stars, Blake Lively and Justin Baldoni. Baldoni and his co defendants, the Wayfair parties, now move for judgment in their favor on all claims. They bring two motions to do so, right here: a motion for judgment on the pleadings and a motion for summary judgment. For the following reasons, the motions are granted in part and denied in part. In particular, the motions are granted except with respect to Lively's fourth cause of action for retaliation in violation of California law against It Ends With Us Movie LLC and Wayfair Studios. Her seventh cause of action against the agency group PR LLC for aiding and abetting retaliation in violation of California law, and her ninth cause of action for breach of an agreement called the Contract Rider Agreement Against It Ends With Us Movie LLC. Do we need to cover the background? The following facts are described in summary form at the outset, with a more detailed description of the evidence recited in the section to which it is relevant. So, the film at the heart of the lawsuit is based on a successful novel by Colleen Hoover. Both the book and film explore issues of TV. The film was co financed and co produced by defendant Wayfair Studios and Sony. Again, Sony, they're too big for Lively. It starred Lively and Baldoni. Lively is a well-known actress. Baldoni is an actor, director, and author. Wayfair is a production studio. It aspires to create purpose-driven films intended to inspire connections and promote social change through authentic, impactful storytelling and fresh creative voices. Baldoni co-founded Wayfair in or about around 2019 or 2020. And defendant Steve Sarowitz. Sarowitz is also the majority. Oh, yeah. Is it just the two of them? Sarowitz is also the majority investor in Wayfair. They both serve as co-chairs of Wayfair. Defendant Jamie Heath is Wayfair's CEO. Baldoni acquired the film rights to the novel in May 2019. In 2022, Wayfair incorporated It Ends With Us Movie LLC to develop and produce the film, which is standard. Later that year, because of things like this, I think, because of like who knows what liability you might have to face. Later that year, after meeting with Baldoni in New York, Lively agreed to play the film's lead role opposite Baldoni. Her agreement to perform that role is documented in an offer letter dated May 4th, 2023. Filming began on May 15th, 2023. It stopped, however, on June 14, 2023, in deference to labor strikes by the Writers Guild of America and SAG-AFTRA. During the first phase of production, all filming took place on a set in New Jersey. As described further below, Lively contends also, I believe, I don't know if Lively herself said it or I don't know, but didn't she convince them basically to have the movie in New Jersey instead of Boston, which they originally wanted to do because the book is set in Boston? Lively contends that various incidents took place during the first phase of filming that amounted to SH sexual harassment and contributed to a hostile work environment. Several months later, on November 9th, 2023, in anticipation of strikes ending and filming resuming, Lively's attorney sent an email to Wayfair and It Ends With Us movie. I'm guessing the listing a set of 17 items that they would have to address to remediate their alleged misconduct before Lively would agree to return to production. The list was entitled Protections for Return to Production. It included, among other things, provisions related to presence of intimacy coordinators on set, blah, blah, blah. On January 4th, 2024, Lively, Baldoni, Heath, and others met at Lively's apartment at her request to discuss her concerns regarding the first phase of production and to approve these conditions. The protections were later incorporated into the contract writer agreement that is still in the breach of writer Um, Production resumed in January 5th, 2024, and took place primarily in the New Jersey set with a few additional days in California. I don't think I knew that part. During the following weeks, the parties worked on editing, promoting the film. Lively indicated that she did not wish to jointly promote the film with Baldoni, concerned that her appearance with him would be viewed as an implicit stamp of trust or approval of him. Convenient, but it was anyway, sorry, whatever. Hi, it's been a while. Arina, Arina, but I like that name too. So where was I? Oh, they unfollowed the Baldoni, blah blah blah. Anyways, procedural history. Lively initiated this case. Oh, and then I don't know, did they mention? Oh, so it stopped on August 6th, this history. Yeah, okay, because then it starts into the case. So August 6th, 2024, the film premiered in New York and was released to the public on August 9th. In the run up to the premiere, and after Lively and her husband had unfollowed Baldoni on social media, Wafer and Baldoni worked with their public relations consultant to engage crisis communication specialists, as well as their respective firms. And what happened next is hotly disputed and will be described below. I like that he said it that way. Um, oh, nice. A sabbatical, like meaning from here or from work or other things. Um, where was it? Lively initial. Okay, so procedural history. Oh, my clothes are done, but they'll wait. Lively initiated this case by a complaint filed on December 31st, 2024. She filed. Sorry, I'm like, wait, the math, because then the article came after the complaint, but the article came around December 21st or 23. She filed the first amended complaint on February 18th, 2025, and the operative second amended complaint on July 30th, 2025. On September 26th, 2025, excuse me, the Wayfair parties filed a motion for judgment on the pleading supported by a memorandum of law and declaration of Ellen Garofalo. November 12th, the Wayfair parties filed a motion for summary judgment. The Wayfair parties also filed a Rule 56.1 statement, um, attaching a large number of exhibits. The declaration of these people, blah, blah. On December 3rd, 2025, Lively filed memoranda of law in opposition to the motion for judgment on the pleadings and the motion for a summary judgment. She also filed a counter statement to the Wayfair parties Rule 56.1. On December 12th, Wayfair parties filed reply memoranda of law in further support of their motion, and the court held an oral argument on the motions on January 22nd, 2026. Okay, legal standard. Judgment on the pleadings under Rule 12C of the Federal Rules of Civic Procedure is appropriate if the movement establishes that no material issue of fact remains to be resolved, such that a judgment on the merits of a case can be made merely by considering the contents of the pleadings. The same standard applicable to this other motion to dismiss applies to this other motion for judgment on the pleadings. Thus, the court must accept all factual allegations in the complaint as true and draw all reasonable inferences in plaintiff's favor, which I believe people are pointing that out. That being said, The court need not accept allegations that are contradicted by other matters asserted or relied upon or incorporated by reference by plaintiff in drafting the complaint. A Rule 12C motion for judgment on the pleadings must be granted unless the complaint includes enough factual matter accepted as true to state a claim to relief that is plausible on its face, a pleading that offers labels and conclusions, or a formulaic recitation, recitare. I know in I'm probably that's also Italian, but I know in Romanian how to pronounce that. Of the elements of a cause of action will not succeed against a Rule 12C motion, nor will a pleading that is only supported by mere conclusory statements. For a plaintiff's claim to be plausible, it must raise a reasonable expectation that discovery will reveal evidence supporting the claim. Summary judgment is appropriate where the movement shows that there is no genuine dispute as to any material fact. A genuine issue of material fact exists if the evidence is such that a reasonable jury could return a verdict for the non moving party. The movement bears that burden of demonstrating the absence of a genuine issue of material fact. In deciding a motion for summary judgment, the court must construe the evidence in the light most favorable to the non moving party and draw all reasonable inferences in its favor. So, like, as a lot of people are saying, Blake had a lot going for her in so many different ways, and this still happened. A party opposing summary judgment must present evidence in a form that would be admissible in evidence. An affidavit or declaration used to support or oppose a motion must be made on personal knowledge, set out facts that would be admissible in evidence, and show that the affiant or declarant is competent to testify on the matters stated. Therefore, only admissible evidence need to be considered by the trial court in ruling on a motion for summary judgment. Blah blah blah. All right, sorry. I hate to do this. I hate to like skip over parts. I know so many people, so many of us do it because these are long. Um, but yeah, in Rule 56.1 of the Local Civil Rules of the United States District Courts for the Southern and Eastern District of New York, prescribes the matter and method in which a party is to present undisputed issues of fact to the court. The moving party must annex to its notice of motion a separate, short, and concise statement in numbered paragraphs of the material facts as to which the moving party contends there is no genuine issue to be tried. And it seems like they did a pretty darn good job because it's a big thing. 10 out of 13 claims have been like thrown out by the judge before the trial starts. So they did their job. Let's get to is a discussion where it all starts, or is there another part? All right. I guess the discussion. That's what I thought. I just wanted to check. All right. So, discussion. This is page 9 out of 152. I thought 75. 152. Lively brings 13 claims against the Wayfair parties. 1. Sexual harassment in violation of Title 7 of the Civil Rights Act of 1964. Against, it ends with us, and Wayfair. 2. Retaliation in violation of the same thing. 3. Sexual harassment in violation of the California Fair Employment and Housing Act. 4. Retaliation in violation of this FEHA, however you want to call it. 5. Retaliation in violation of California Labor Code Section 1102.5. 6. Failure to investigate, prevent, and/or remedy harassment in violation of FEHA. 7. Aiding and abetting harassment and retaliation in violence of FEHA. 8. Breach of an agreement called the Actors Loan Out Agreement. 9, breach of the contract writer agreement. 10, false light invasion of privacy in violation of Article 1, etc., etc. 11, sexual harassment in violation of California Civil Code, Section 51.9. 12, defamation and defamation per se. And 13, civil conspiracy against all of the defendants. There are two pending motions. The Wayfarer parties move for judgment on all claims. Their motions for judgment on the pleadings and summary judgment overlap in many respects. To the extent that they do not, however, the parties dispute whether the court. Wait. Oh. To the extent that they do not, however, the parties dispute. Wait, my brain is not registering that English. Just moving on. The parties dispute whether the court should, in considering the motion for judgment on the pleadings, also consider factual disputes presented in the motion for summary judgment. Lively contends that even if the Wayfarer parties have identified some deficiency in her pleadings, the court should conform the pleadings to the evidence in the summary judgment record and evaluate Wayfarer parties' arguments on that basis. The Wayfarer parties respond that the motion for judgment on the pleadings tests the sufficiency of the pleadings and that the court therefore must not consider extraneous materials outside the pleadings in its analysis of that motion. Okay. A recent Second Circuit decision sheds light on this issue and it suggests that Lively has the better of the argument. The circuit addressed a situation in which, following extensive discovery, the defendants moved for summary judgment, arguing both that the complaint failed to state a claim and that the summary judgment record did not create a genuine dispute of material fact. In addressing the motion, the district court confined its analysis to the defendants' arguments regarding the sufficiency of the pleadings. The circuit explained that the decision was error. Once discovery has been completed, as here, we do not regard the pleading standard as requiring the defendant's Rule 12C motion be granted if evidence that had already been produced during discovery should fill the perceived gaps in the complaint. It added, even if the allegation in the complaint were insufficiently detailed to survive a motion to dismiss, had such a motion been made before discovery, if the evidence collected in discovery raised triable issues of fact, it would have been appropriate of or for the plaintiff to amend her complaint to confirm to the evidence thus collected. Dismissing the complaint at that stage when the evidence adduced in discovery may have been sufficient to survive a summary judgment motion would hardly serve the efficient or just resolution of disputes, which is very foundation of the federal rules. So here, the parties have completed an extensive and fiercely contested discovery process. The Wayfarer parties' motion for judgment on the pleadings came toward the end of that process and only shortly before its motion for summary judgment. In these circumstances, it would hardly serve the efficient or just resolution for this dispute for the court to limit its analysis solely on the pleadings rather than the entire record of summary judgment. In any event, the dispute ultimately matters very little, as the Wayfarer parties have identified only a handful of allegations which they believe should be disregarded in consideration of the motion for judgment on the pleadings. And those allegations are immaterial to any determinations the court reaches. The court starts with Lively's contract claims. It then proceeds to discuss her federal claims, her California statutory claims, and her common law claims. So, contract claims. I'm debating whether I should go like change my laundry right now because this will be a while. Let's do a couple here. Oh my gosh, it's only been 50 minutes. Wow. Lively brings contract claims against It Ends With Us movie and Wayfarer for their purported breach of two agreements. referred to as the actor loan out agreement and the contract writer agreement. Her eighth cause of action alleges a breach of the ALA, actor loan out agreement, and her ninth cause of action alleges a breach of the CRA. Lively grounds her claims in two provisions. Okay. They argue in the alternative that even if the agreements were or are enforceable, was neither a breach nor cognizable damages. Oh, Wayfair and it ends with us respond to this by saying that the court recounts the facts relevant to these claims before analyzing the merits of the parties' respective. So, factual background. Mm, okay. Formal negotiations regarding Lily's appearance in the film commenced in mid-December 2022. Oh, I like that name. Imen. I'm guessing Imen Mizian or something. I mean, either way, it sounds really pretty. Wayfair's vice president of business and legal affairs sent Lively's representation a draft offer letter. Following additional negotiations and exchanges of drafts, the parties circulated a final version of the offer letter on May 4th. That letter sets forth an agreement between Lively's loan out entity, Blaco Inc., and it ends with us movie, the special purpose entity for Wayfair to make this film. Blakel agreed to furnish Lively to provide acting services to It Ends With Us in the role of Lily Bloom. Among other things, the offer letter specifies the timing and location of filming, Lively's compensation, her mutual approval rights over certain aspects of the production, and her credit as an executive producer. It states that Lively agrees to provide exclusive principal photography services for up to 6 consecutive weeks during the run of production. The offer letter contains no terms regarding sexual harassment. Paragraph 13th of the agreement, titled Condition Precedent, provides that producers' obligations to artists hereunder shall be subject to the satisfaction of full execution by artist, lender, and producer of an agreement in a form reasonably acceptable to all parties. In contemplation of additional negotiations to follow, the letter also states that once this is like a great summary of what's been happening. Um, I like this. I feel like I'm learning a lot and I'm getting like a clearer picture because it got muddy so many times. In contemplation of additional negotiations to follow, the offer letter also states that once we reach an agreement on the above terms, we will be happy to distribute a long form agreement incorporating the terms herein and other standard terms, including without limitation premieres, publicity, travel expenses, indemnity, insurance, etc., and conditions to be negotiated in good faith. Yeah, the good faith was not there. 4 days late on her part, allegedly, in my opinion. 4 days later, on May 8th, 2023, Joseph Lenius, outside counsel for It Ends With Us movie, sent Lively's counsel a draft of the ALA, which would serve as the long form agreement mentioned in the offer letter. As with the offer letter, the draft lists the parties to the agreement as It Ends With Us movie and Blakel Inc. Excuse me, with an inducement to be signed by Lively. Waiver was not made a party or signatory to the draft agreement. The first section of the draft is titled Conditions Precedent and provides companies' obligations under this agreement are conditional upon certain circumstances, including as relevant here. One, companies' receipt of executed copies of this agreement signed by lender and artist, Blakele and Blake, and companies, right? And companies' receipt of the inducement attached hereto and incorporated herein by this reference, fully executed by lender and artist. The draft ALA also contains an entire agreement provision incorporating certain standard terms. Um, oh, okay. And specifying that the ALA, including the standard terms, constitutes the entire understanding of the parties hereto and replaces any and all former agreements, understandings and representations relating in any way to the subject matter hereof. The ALA adds that no modification, alteration, or amendment of this agreement shall be valid or binding unless it is in writing and signed by both parties. The standard terms, hence the 17 points, I guess. The standard terms appended to the draft agreement include several provisions relevant for present purposes. So one of them, section 4.3, states no act or omission of company hereunder shall constitute an event of default or breach of this agreement unless artist shall first notify company in writing setting for such alleged breach or default and cure the same within 30 of such notice, which they did cure. I don't know. Section 5 states all notices required hereunder shall be in writing and shall be given either by personal delivery, telecopy, fax, email, provided that no subsequent delivery failure notification is issued by the sender's email server, like failed to deliver email, or by United States mail, postage prepaid. Section 15.1 states the internal substantive laws as distinguished from the choice of law rules of the state of California in the United States of America applicable to contracts made and performed entirely in California shall govern the validity and interpretation of this agreement. The performance by the parties of their respective obligations hereunder and all other causes of action, whether sounding in contract or in tort, arising out of the relating to other arising out of or relating to this agreement or lender's engagement and or artist's services hereunder or the termination of this agreement, engagement services or otherwise relating to the picture. Non-waiver effects under section 15.3 states no waiver by lender, artist, or company of any failure by the other. Oh my gosh, I'm realizing how much like I'm struggling to read and I'm already like out of energy, out of steam, and we're only on page 14. I have read so much in the past, so many pages, almost nonstop. So no waiver by lender, artist, or company, or any failure by the other to keep or perform any covenant or condition of this agreement shall constitute a waiver of any preceding or succeeding breach of the same or any other covenant condition. And 15.6, oh, there's more. The rights and remedies of lender. Okay, you know what? I'm going to skip this because honestly, I'm not really registering these words. And I'm curious, like, okay, what's a decision and why by the judge? Because that's what we're here for. Some of this is like definitely helpful, but yeah, okay. The LA was not signed when the first phase of filming began 1 week later on May 15th, 2023. In fact, although negotiations continued for more than a year, the parties agree that Lively never signed the ALA. Lively's lawyer sent Lanius an email stating, "Thank you for sending the long form. We will review and come back to you with our comments. In the meantime, since principal photography has commenced, until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the offer letter with the understanding that lender and artist are now unconditionally pay or play for the acting fee of 1.75 million and that the conditions in paragraph 13 of the deal memo are now either satisfied or waived. So my understanding of that is basically they agree to the contract. Like, okay, yeah, we haven't signed it, but we agree. Like, we're going to adhere to this contract, to this offer letter, but contract. Gottlieb, oh, that was the evidence or whatever. There is no evidence of a response from counsel for It Ends With Us movie, and principal photography continued. In February 2024, approximately 9 months after It Ends With Us shared a draft of the ALA with Lively, and just days before filming wrapped, Lively's representatives finally sent a marked up version of the agreement. Oh, Lively proposed revisions to approximately 20% of its provisions. How convenient. Like, you know what? I'm going to sit back because this to me sounds like, it was not in good faith that she didn't sign and she continued, that all of this was in bad faith. That's what it sounds like to me, that she stayed on signing and suddenly came back. Actually, after we already pretty much completed 90% of this, or, more like probably 80%, because there's also she wanted to be part of the post part of the movie. But yeah, like now I changed my mind on 20% of these things, or like I have more to add. I mean, that was the thing is too, that was part of the agreement. She could have just signed it and said, "Oh, I need some, you know, changes or something." But also, how convenient. And also, why is my battery draining so fast? Let me finish this. I'll plug in and I'll go change my laundry. But yeah, in February 24th, okay, this happened. Um Including ones related to execution of the ALA, publicity limitations, still approvals, sexual harassment, and confidentiality. Because, right, it seems almost like she waited. It seems like she had a plan to like later cause problems. That's what it looks like to me. Allegedly, like I said, this is what it seems like. She planned it all along, is what it looks like. Not saying it happened that way. I'm saying that's what it looks like. When you come back, you didn't sign the agreement. You agreed to the contract and the agreement, but you didn't sign it. But then you're like, hold on, did the whole thing, and now I want to add these other things once I'm going to claim that they already happened. Among other things, Lively's counsel amended paragraph 7 of the standard terms, the sexual harassment provision, to add that sexual harassment was not only cause for immediate termination of this agreement by company, but also by artist. Further added the following sentence to the conclusion of paragraph 7. In the event that, sorry, let me highlight this. In the event artist is aware of any sometimes it's easier to say SH, conducted by company, notwithstanding the terms of paragraph 16.6 below, lender and or artist shall have the right to terminate this agreement, shall remain entitled to full compensation, and shall have the right to avail themselves of all rights and remedies hereunder and under applicable law. So any SH conducted by company. I'm curious what not like paragraph 16.6 is. Is it here? No. But that sounds so fishy. It sounds so fishy. Elsewhere in the ALA, Lively's counsel struck from the document two conditions precedent specifying It Ends With Us obligations under the agreement were conditioned upon its receiving. One, executed copies of the ALA signed by lender and artist. Two, executed copies of the inducement attached to the agreement. Council added comment bubbles to these provisions, stating company has effectively waived this condition in practice. And of course, this is part of signing a long form, but it is not a condition precedent to your obligations at this point. At this point in time, filming had nearly concluded, and the parties had already conferred certain benefits upon one another. Um, yeah. So, contract. Lively had provided her acting services to It Ends With Us. It Ends With Us, meanwhile, had wired Lively's upfront fee of 1.75 million, less 6.37% New Jersey withholding tax, to Lively's client trust account at WME. It Ends With Us did so even before the offer letter was finalized. It had also paid for Lively's meal and training allowances and booked her travel, which, based on my tiny experience with business law in college, therefore they have a contract. Both parties executed, I mean, and that's what it's saying. They did their part. Lively did her part as acting. It Ends With Us sent her the money. So therefore, we have a contract, whether you signed it or not, basically, is my limited understanding about contract law. That's a very limited understanding. Um, and I think there were exclusions, I think. So it all, yeah. So, and then paid not just for the services, but like all of these other things. Oh my gosh, what is draining the battery? Hold on. How much do I still have? Because I need to like change the laundry. I'll be back. I'm sorry for that one other person that came on. I will be as fast as lightning, but be right back. Sorry. Meantime, there's the parakeets. I'm back. All right. Wow, that was like the fastest laundry change ever. And sorry, my parakeets were sleeping further up. I was like, it's going to be faster if I just leave it out. So, contract created. Let's pick it up from there. So like when I hear these numbers, $1 million minus tax, whatever. How much is that actually? That is like insane. 1, 2, 3, right? Yeah, 6 zeros. I'm just doing. Well, let's do 175, right? 1, 2, 3. Minus. 6, sorry, minus 6%, 37%. So that's 1,638,525. Yeah. All right. Just saying. It's interesting times, interesting things, interesting ways that we pay each other. Okay. So this is where we're leaving off. We left off. It ends with us movies council flatly rejected these proposed revisions in correspondence on March 7th, 2024. With respect to the sentence added at the end of the SH provision, it ends with us movie wrote, "This is not acceptable. There can be no instances where there is a right to terminate the agreement or have a right of injunctive relief." It ends with us also rejected Lively's attempts to remove the condition precedent from the agreement in response to Lively's assertion that the requirement of an executed ALA had been effectively waived in practice. It ends with us, counsel stated it still needs to be left in as it is always in every deal I have ever done. It ends with us, movie similarly responded to the comment bubble asserting that execution of the inducement was not a condition. Uh, it was not a condition precedent to your obligations at this point, stating yes, having a signed agreement along with all exhibits is always a condition precedent. Okay. Disagreement over the terms continued with Lively reintroducing the edits in a draft on April 18th, 2024. And it ends with us further rejecting them once again in a subsequent draft. Following these exchanges, Heath told Lively's representation in a May 3rd, 2024 email that we, sorry, we have withdrawn our request for your client to sign her agreement in order to extend the time with the edit. The end of that email notes, as for the future resolution of the contract, we will stand by in hopes that we come to a conclusion soon. Yeah. Hope was is where hope and it doesn't do much. She's like, I don't know what she was doing. Um Sorry, poop happens. The parties exchanged a final draft of the ALA on July 2nd, 2024, with disputes regarding the contested provisions still unresolved, and Lively's proposed additions once again struck from the document. This is, man. In that correspondence, Ms. Yan wrote to Lively's counsel seeking an expedited review and signature. Ms. Yan's request followed. Like, I don't even know, like, what leg do you have to stand on when the person already provided her services? I guess, like, what they were going to say, well, we're not going to release the movie because she didn't sign the agreement. Like, what could they have possibly have as leverage to make her sign? It already happened, they had leverage before they started and everything was done. In correspondence, Ms. Yan wrote to Lively's counsel seeking an expedited review and signature. Her request followed a similar one she made 2 months earlier, in which Lively's representatives had responded at the time. We, Blake's reps, are all speaking this week about the open issues and will come back to you soon. Notwithstanding these and other requests, Lively never signed the ALA. Non-party Sony executive Angie Giannetti stating that Wayfair had been trying to get Lively to sign her deal for over a year. Baldoni stating in a June 1, 2024 text that Lively won't sign her contract. All right. That brings the court to the CRA and other agreement under which Lively seeks relief. As previously noted, filming paused on June 14, 2023, approximately 1 month after it began, due to the Writer Guild bubble, the strike. In an email on November 9th of that year, Lively's attorney informed Mizian and Lanius that Lively's experience during the first phase of filming had been deeply concerning on many levels, and that a list of protections would need to be guaranteed and observed by the film's producers in order for her to feel safe to return. The email states that while we reserve all legal rights at this stage, our client is willing to forego a formal HR process in favor of everyone returning to work and finishing the film as long as the set is safe and moving forward. It continues that if the production is unwilling to accept or uphold these procedure protections, our client is prepared to pursue her full legal rights and remedies. 2 days later, Ms. Yan responded, Wayfair, Sony, and production respectfully acknowledge that your client has concerns regarding safety, professionalism, and workplace culture. Although our perspective differs in many aspects, ensuring a safe environment for all involved is paramount, irrespective of differing viewpoints. So basically, they said, okay, like we don't agree necessarily that these things happen, but like we agree that safety is important. Regarding your outlined requests, we find most of them not only reasonable but also essential for the benefit of all parties involved. Although Ms. Yan agreed to many of the protections, she sought clarification regarding others and stated that one, Lively's request to engage an additional producer to supervise the production was not viable. Lively's representative replied that this list provided was not intended as a starting point for negotiation, but rather was necessary for Lively to return to work. Period. The representative further requested that Ms. Yan respond as soon as possible whether Wayfair will agree to accept all the protections included in our original communications. On December 15, 2023, Lively provided Ms. Yan with a side letter which outlined the list of 17 protections provided in the November email, along with certain updates and minor modifications. Lanius confirmed receipt of this document, also known as the Contract Writer Agreement or CRA, and in an email on January 3rd, 2024, proposed certain revisions. It's like, the what's the word, the phrasing, like the ball keeps changing, it keeps moving, the ball keeps moving. I don't know. On or about January 19th, 2024, Heath, acting on behalf of It Ends With Us movie, signed the CRA. Lively also signed the agreement. Sony executive Angie Giannetti testifies at her deposition that It Ends With Us executed the CRA because there was a tremendous amount of money that had been invested and spent, and we had to finish the movie or it was unreleasable. The final CRA began by stating that reference is made to the ALA and that the parties, meaning It Ends With Us as company, Bleak Link as lender, and Lively as artist, wish to confirm that the conditions under which lender has agreed to cause artist to render acting services on the picture following the break in production. Um, Is that a full sentence? Anyways, a prior version of the CRA referred to the ALA as unexecuted, but Linnaeus deleted that word in a draft among other edits. The CRA further states that for the good and valuable consideration, the receipt of which is hereby acknowledged, Um, it ends with us agrees to certain additional terms and conditions, including the following condition found in paragraph 10, that there shall be no retaliation of any kind against artists for raising concerns about the conduct described in this letter or for these requirements. Any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work as a result of these requests, is retaliatory and unacceptable and will be met with immediate action. And the CRA states that in the event of any conflict between the terms and conditions of the agreement and the terms and conditions of this side letter agreement, the terms and conditions of this side letter agreement shall control. Although the initial November email with the protections for return, I'm already kind of like over this. Not gonna lie. It's been how many? What, 2 years? I mean, 1 year and a half. And then if you count like a little bit of beforehand, like the December one, yeah, it's 1 year and a half of this. And this is just, man, I don't know. Although the initial November email with the protections for return to production indicated that if the protections were exceeded, to Lively was willing to forgo. Oh my gosh. Why is my brain just registering some of these things as like that's not making sense? Like the grammar, I'm missing some some things. Was willing to forego a formal HR process. The CRA contains no such promise on its face. When the CRA was signed in January 2024, the parties were still actively negotiating at least certain portions of the ALA, including the provisions governing stage, and no long form agreement had been signed. So the ALA is unenforceable. They contend, it ends with us and Wayfair contend principally that the ALA was never validly formed and is unenforceable against them because the agreement contains conditions precedent, namely execution of the agreement and lively signing of the inducement, that did not occur. The services will like happen, the transaction between the two people happen. Lively responds that they are is stopped from raising such an argument by their prior efforts to enforce the agreement, and that in any event they have waived the conditions through their conduct and writing. Yeah. Before turning to the merits, why did it do that? The merits of these arguments, the court addresses two preliminary issues. The first relates to the choice of law in discussing the contract claims. The parties both invoke California and New York law. The court will do the same, as courts have observed that New York and California apply substantially similar rules for determining whether the parties have mutually assented to a contract term. Great. Furthermore, to the extent the two states' laws do conflict on such issues, any differences are immaterial and detailed below. The Wayfair parties also make certain alternative arguments going beyond formation, which assume arguendo that the ALA is binding. Because these arguments that the ALA's validity as their premise, the court analyzes them in accordance with the ALA's California choice of law provisions. I don't even know what that meant. I don't even know at this point. I don't know. Also, I don't understand what is like making my computer like it's heating up, and I can't make sense of that because that doesn't happen with this laptop. Like what is happening? Nothing's like going besides YouTube. That's so weird. Anyways, all right. The second preliminary issue is which defendants are now subject to Lively's contract claims. The SAC pleads contract claims against both It Ends With Us movie and Wayfair. It is undisputed that only it ends with a Smoothie and not Wayfair is a party to the ALA and the CRA. Wayfair therefore argues in its opening brief that it is not liable under the agreements. In her Rule 56.1 statement, Lively suggests that Wayfair is bound by the agreements even if it was not listed as a party. Her brief in opposition to the motion for summary judgment, however, fails entirely to respond to the Wayfair party's arguments as to why Wayfair should not be held liable under the agreements. Given this failure to respond in viewing the papers and circumstances as a whole, the court deems her contract claims against Wayfair abandoned. In the case of a counsel, okay, so then it's saying, like, you know, this was what happened before. Lively asserts that the Wayfair party's arguments regarding the validity and enforceability of the ALA are all besides the point because the Wayfair parties themselves previously sought to enforce the agreement against Lively and therefore are stopped from disputing its enforceability now. Was it just me, or like did that change like who wants the ALA to be valid or not? Um, Wait, because the parties themselves previously sought to enforce the agreement against Lively and are therefore stopped from disputing its enforceability now. Judicial estoppel applies where one, a party's later position is clearly inconsistent with its earlier position. Two, the party's former position has been adopted in some way by the court in the earlier proceeding. Three, the party asserting the two positions would derive an unfair advantage against the party seeking estoppel. The Second Circuit has further limited estoppel to situations where the risk of inconsistent results with its impact on judicial integrity is certain. Those circumstances are inapplicable here. Lively's argument is predicated upon the Wayfair party's assertion of a claim for breach of the implied covenant of good faith and fair dealing filed in this court on January 16, 2025. In an amended complaint filed on January 31st of that year, the Wayfair parties alleged a claim that against Lively for breach of the implied covenant of good faith and fair dealing. Lively moved to dismiss the amended complaint, arguing in relevant part that the implied covenant claim had to be rejected because the Wayfair parties had failed to identify the relevant contract, any of its terms, who it was with, or how it was breached. The Wayfair parties opposed that motion without specifying a provision of a contract under which their claim arose, but also while quoting a fragment of a sentence of language that appears in the ALA without citation. Wayfair action, quoting language that Lively agreed not to interfere with the complete enjoyment of the rights and privileges granted to Wayfair language, which appears in the ALA but not in the offer letter. The Wayfair parties did not attach the ALA to the amended complaint, and the quoted fragment appeared nowhere in the complaint. In its June 9th, 2025 opinion and order granting the motion to dismiss the amended complaint, the court dismissed the Wayfair parties' implied covenant claim on the grounds that the complaint's allegations were conclusory and failed to identify the relevant contract which individuals were parties to when it was made or what the relevant terms were. Lively's estoppel agreement is without merit because the Wayfair parties did not previously assert that the ALA was enforceable, nor did the court adopt any such position in dismissing the Wayfair parties' amended complaint. Wait, Lively's estoppel argument is without merit because Wayfair did not previously assert that the ALA was enforceable. The court did not adopt any such position either. In dismissing the Wayfair party's amended complaint, The court concluded that they had provided insufficient information regarding the specific contract under which they were suing. It granted them leave to replead their contract claim with allegations identifying the relevant agreement and provisions, which they chose not to do. The court's holding, therefore, necessarily did not address whether the ALA was validly formed or enforceable. The risk of any inconsistent results in consistency results is therefore not only far from certain but not existent. For similar reasons, there is no apparent possibility of an unfair advantage. To the extent Lively argues that the Wayfair parties should be prevented from disputing the ALA's validity, not under the doctrine of judicial estoppel, but from the different framework of waiver, the court addresses and rejects the contention below. So contract formation. It ends with us. Movie raises two variants of the same core argument regarding why the ALA is unenforceable. First, it contends that ALA was never a validly formed binding contract because it ends with us expressed an intent not to be bound until Lively executed and signed the contract. It ends with us never renounced that intent, and Lively never executed and signed the agreement. Second, it ends with us contends that even if the LA was a binding contract, it specifically provided that it ends with us obligations did not arise until the signing of the agreement. Because the conditions never occurred, its obligations never kicked in, and it cannot be held liable under the agreement. These are arguments, therefore, these two arguments therefore end up in similar places through different doctrinal routes. The court will address both, turning first to the issue of formation. Mutual intention to be bound by an agreement is the sine qua non, I don't know, of legally enforceable contracts. And recognition of this requirement is nearly universal. Mutual. So this other case, mutual assent is essential to the formation of a contract, and a party cannot be held to have contracted it if there was no assent or acceptance. From this foundational principle, it follows that if either party communicates an intent to not be bound until they achieve a fully executed document, no amount of negotiation or oral agreement to specific terms will result in the formation of a binding contract. If there is a manifested intention that the formal agreement is not to be complete until reduced to a formal writing to be executed, there is no binding contract until this is done. Put another way, when the circumstances and evidence suggest that both parties contemplated that acceptance of a contract's terms would be signified in writing, the failure to sign the agreement means that no binding contract is created. Okay, so because they said, hi April, so because they said that both parties, if I'm understanding this right, said, well, we're not this contract will not be valid until we both sign it, and they both stated that, they both said that was the intention, therefore that's why the contract is not binding, right? Also, yeah, uh yeah, so sabbatical from legal battle. Sorry, I got into this. Whoops. I Like I said, I'm already like over reading this. It is I don't know. I've just kind of been over this case. This is why I'm consistency is not my strength. And why I'm not doing so good on YouTube or anything. I just burn out. My attention is like, okay, new shiny thing, and yeah, but like I'm getting back into it as I'm going through this. I'm like, ooh, that's so exciting and so good to know, and it's clarifying so much. Um, the way that it's presented, it's very like specific and directional. Um, but yeah, so I understand the sabbatical from this legal battle or anything like this. Um, but yeah, it's um I don't know if he'll be all right. I think both of them have the potential to be all right, not right away. And again, I don't really know what Hollywood thinks of him, because at the end of the day, it seems also that Hollywood, it doesn't really care about justice or fairness or redemption or whatever unless it makes them money. And so I don't think Hollywood might stay away from Justin because he's wrong, or go towards him because he's been proven his case was dismissed as far as like, the serious allegations. But it's still like, you know, I don't know. I don't know. I feel like it's still so affecting. What we've seen so far is, for whatever reason, it affected his employment on other projects and his other projects and projects that he was attached to. Those were affected. She and her projects and things that she was going to do and sign up for was not affected. And so, even though we want to see that good wins, like, I don't think Hollywood is really about that. I think they're about like the connections and who's like holding what over your head. And Justin doesn't have that leverage. Bleak Lively and Ryan Reynolds do. And so, who would give him a shot? I mean, he already had to create his own production company, or didn't have to maybe, but like he wanted to. And um I don't know. I don't know. It's going to be interesting. But yeah, his name, his reputation, him period has been dragged through the mud. A lot of people, like a lot of people, even with us, checked out. We're like, we believe his innocence and et cetera, but like we just can't do this anymore. um Same with like movies. I had started watching Wayfair movies, um but at the same time, it's hard to watch something that I'm not that interested in. Like Eleanor the Great, I've not watched. It's awarded and nominated and tooted and all the stuff, but I'm like, this case and wanting to support Justin, like, yeah, I want to watch that movie, but like I really just, I wouldn't otherwise. And there's another movie. Um so there might have been like an influx and something, but as long as, I don't know what will happen afterwards. And like I said, I don't know. um I don't even know if he's like, okay, I'm I'm gonna like do other things now. And yeah. um yeah. Yeah, this is this has been like tough. um all right, back to this. Oh my gosh, where was I? This touchstone of contract formation. So parties, agreeing that the term of this contract means that they both signed it. This touchstone of contract formation, intention to be bound, must be assessed based on the totality of the circumstances, including the parties' words and conduct. Mutual assent is determined under an objective standard applied to an outward manifestation or expression of the parties, blah, blah. Questions of intent to be bound often arise in situations involving preliminary agreements that call for the subsequent execution of more formal instruments. The Second Circuit has identified two types of such agreement. The first arises where parties agree on all points that require negotiation, including whether to be bound, and they contemplate memorializing those points in a more formal document. Such agreements are fully binding as they are preliminary only in form, only in the sense that the parties desire a more elaborate formalization of the agreement. The second situation arises where the parties agree to some major terms, but others remain to be negotiated. Excuse me. In this context, courts look to certain factors to determine whether the parties intend to be bound, including language of the agreement, context of the negotiations, existence of open terms, partial performance, necessity of putting the agreement in final form, and as indicated by the customary form of such transactions. There is a strong presumption against finding binding obligation in agreement which includes open terms, call for future approval, and expressly anticipate future preparation and execution of contract documents. That said, courts must remain mindful that these factors help us identify categories of facts that are often useful in resolving disputes of this sort, but they do not provide us with a talismanic scorecard. The ultimate issue, as always, is the intent of the parties, whether the parties intended to be bound, and if so, to what extent. Applying these standards of the facts to the facts of this case, it is clear that the ALA is not and has never been a validly formed and binding contract, as it ends with us unambiguously expressed an intent not to be bound absent of a fully executed and signed agreement. Consider first the language of the agreement. In both offer letter and ALA, it ends with us expressly reserve the right not to be bound prior to execution. Offer letter states producers' obligations to artists hereunder shall be subject to full execution by artist, lender, and producer of an agreement in a form reasonably acceptable to all parties. The LA contains similar language. The first draft and all subsequent ones shared by It Ends With Us asserts that It Ends With Us is not to be bound absent receipt of executed copies of this agreement signed by lender. Why are there so many repetitions of the same thing? The ALA also states that It Ends With Us is not to be bound unless it receives the inducement attached hereto and incorporated herein by this reference, fully executed by lender and artist. This express reservation of rights absent a signed writing is not one or two, but three different places, in not one, is compelling evidence that there was no mutual assent to the formation of the contract. Sorry, my leg. Oh boy. Okay. That inference finds support elsewhere in the ALA. This agreement contains a merger clause which specifies that the parties' agreement is expressed entirely in the document and that it may not be modified, altered, or amended unless in writing and signed by both parties. The standard terms also contain a provision requiring amendments to be in a written instrument executed by company and artist. The presence of such a merger clause is persuasive evidence that the parties did not intend to be bound prior to the execution of a written agreement. Where a question of intention is determinable by written agreement, the question is one of the law appropriately decided on a motion for summary judgment. That is the case here. Include open terms, call for future approvals, and expressly anticipate future preparation and execution of contract documents. The message is clear. It ends with us did not intend to be bound prior to execution. Why are we repeating this so many times? I'm sorry. I'm sorry. Like I understand, I guess, like the part where you have to dot all the I's and cross all the T's legally in a legal document and all this stuff. And these like little repetitions are somehow just adding detail. But it just seems like I've said the same thing 15 times. Like, okay, done, resolved, understood, next. That's what it feels like reading this as me and not like a lawyer or someone who's like, oh yeah, this is so necessary. Like, I'm like, okay, you said this. Can we move on? Or can we have like bullet points or whatever of like, they intended to not be bound prior to execution. Here is why we are saying this because of this, because of that, etc. Don't just like repeat. They did not intend to um, be bound prior to her signing. They did not intend. Like, why are we repeating this? I'm sorry. I'm sorry. I signed up for this. I decided to read this as is. It's getting to me. It's getting under my skin. Since in this case, intent uh, can readily be determined by examining the agreements, summary judgment is perfectly appropriate, even if there was considerable partial performance. Additional factors, including the context of the negotiations, confirm that the agreements on their face suggest it ends with us on multiple occasions sought Lively signature on the ALA. Lively on multiple occasions withheld it. Those requests and that withholding were not meaningless. They hold on. They evidenced the parties shared understanding that execution of the ALA carried with it legal consequences. Lively argues that her withholding of her signature suggests that at most that the parties continued to disagree over a limited subset of terms, in her estimation about 20%, not that they disagreed over the information of the contract in general. But 20% of an agreement's provisions is not an insubstantial amount, and the specific provisions at issue also are not insignificant or immaterial to issues of formation. One of the contested provisions is the very one under which Lively now sues, paragraph 7, which prohibits SH and retaliation. Lively contends that the parties' disagreements over paragraph 7 centered on her right to injunctive relief, which is not an issue here, or not at issue here, and that there is no evidence that the parties disagreed over the rest of the provisions. That slices matters too finely. Oh my gosh, like such a nice breath of fresh air when there's like a, regular English phrase like that and not like a technical legal one. The court cannot infer a party's agreement to parts of a provision from the fact that the party has expressly disagreed to other parts of the same provision. It is an elemental principle of contract law that a written contract will be read as a whole and every part will be interpreted with reference to the whole. The question whether Lively would have the unilateral right to halt production of the film if in her view of SH occurred is hardly inconsequential. The fact that the parties were not able to come to terms on such provisions provide powerful evidence that no contract had yet been formed. So this is kind of what one of the things that I heard Ashley kind of highlight in her live, basically like interpreting this to say the court finding that her power to stop production is notable. Resisting the conclusion of Lively contends that the parties' partial performance of the ALA and their written statement about it reveal that they intended to be bound, notwithstanding the agreement's clear language to the contrary and the parties' continued negotiations. The court disagrees. Ooh, a short sentence. Love it. Considering Lively's evidence both in isolation and as a whole, it fails to raise a genuine issue of material fact concerning formation of the ALA. To start, Lively asserts that it ends with us intent to proceed with the agreement can be inferred from the fact that it performed the material terms of the ALA, that they send the money and stuff. Or that, yeah. Had there been no contract, Lively argues it ends with us would have had no reason to perform under it. That's what I was thinking and saying. Partial performance is relevant as one party's partial performance of the alleged contract and the other party's acceptance of that performance shows that both parties understood a contract to be in effect. However, as the Wayfarer parties argue, their performance took place under the offer letter, not the ALA. Okay. Semantics. After filing began and well before Lively responded to the Wayfarer party's draft of the ALA, Lively's counsel stated to It Ends With Us that because principal photography had commenced until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the negotiated deal memo, i.e., the offer letter. It ends with us did not respond that thus tactically accepted and thus tactically accepted that position, treating the offer letter as the binding agreement, not the contract, the ALA. Um, Lively cites it ends with us conduct after it circulated a draft of the ALA, but each act was consistent with the offer letter. Lively cites it ends with us payment to Blakel of meal and training allowance as proof that the LA, you know, contract exists, performed, blah, blah, blah. Letter also provides for such allowances. Lively also observes that it ends with us charted a private plane for her travel. The offer letter requires it ends with us to provide private round trip air transportation for Lively during shoots outside of New Jersey and New York. The parties conduct during filming, therefore, um, the parties' conduct during filming therefore reinforces what Lively's counsel made explicit that the parties would perform under the offer letter until such time that the long form is fully executed. As for the parties' post filming conduct, Lively argues that she was paid after the film's release in accordance with the more generous contingent compensation arrangement outlined in the ALA rather than under the offer letter. But a party can provide a more generous benefit to a counterpart in anticipation that an agreement will be reached without, at the same time, committing itself to all of the terms in a written agreement before the agreement is reached. Um, that is the case here, even when partial performance strongly favored finding existence contract. There is no evidence that It Ends With Us provided those benefits because it believed that it was bound by the ALA. But the but by the time of post production, Lively had repeatedly rebuffed It Ends With Us entreaties for her to sign the ALA. It Ends With Us also had repeatedly and unequivocally rejected Lively's counsel attempt to strike the execution language from the agreement. Even assuming that Lively is correct and that It Ends With Us paid her under the ALA, that partial performance cannot reasonably be understood to reflect that what would be a conspicuously silent change of heart on It Ends With Us part. So I thought that Wayfair wanted the contract to be withstanding, to like actually be accept or seen as a contract. I understand now Lively wanted that for I'm unclear of the reasons of what benefits mm, because if there's a contract she's can happen, I guess. I don't know. But either way, so where we are now, like It Ends With Us is like, no, the contract was not valid because you never signed it. She's fighting for it to be valid because she didn't sign it, but she performed the duties and they paid her for it, and did all the stuff. So it seems like her strategy to not sign the contract is biting her in the butt. It seems like someone did not know law in like advising her in her decisions, I guess. Lively also relies on certain statements made by the parties during negotiations as further evidence to their intent to be bound. These likewise fail to raise a triable issue as they cannot fairly be read to carry the implications Lively assigns to them. First, Lively points out that when her counsel sought to strike the conditions precedent from the ALA on the grounds that they had been effectively waived in practice. It ends with us. Counsel responded that the conditions should still remain because they are always in every deal I have ever done. Lively contends that because it ends with us, counsel did not expressly dispute waiver of the conditions precedent. Sorry about parakeet butt over there. It ends with us conceded the issue. A party need not sue the magic words. Why did I read that as sue? A party need not use the magic words I contest waiver, where its actions do just that. Um, It ends with us refuse to agree to remove the relevant language, continuing to insist that Lively deliver a final executed copy of the ALA before it would be bound. Nor does Heath's email to Lively's representative on May 3rd of 2024 provide evidence of an intent to enter into the ALA. At the time, the parties still had not reached agreement on the terms of it. It ends with us had rejected Lively's proposed changes. Lively states that Heath, in the email, expressly confirmed in writing that Wayfair was waiving the execution conditions, but this is misleading. It is in its entirety. The relevant sentence from the email reads, "We have withdrawn our request for your client to sign her agreement in order to extend the time with the edit." The email continues, "As for future resolution on the contract, we will stand by in hopes that we come to a conclusion soon." Heath clearly did not understand the contract. Hi, Vigo. He did not understand the contract to be resolved or concluded, nor did he agree that Lively did not need to deliver final executed copies of the ALA. He merely communicated that Lively could edit the film while negotiations were ongoing. Indeed, after this email, it ends with us continued requesting Lively's expedited review and signature on the ALA, and Lively continued to refuse to do so. Baldoni stating in a text that Lively won't sign her contract. Um, I don't know what that means, Vigo. Finally, Lively seizes on the fact that on January 3rd, during negotiations over the CRA, it ends with us struck the word unexecuted from the phrase unexecuted actor agreement. The fully executed CRA states that reference is made to that, and also half an hour ago, maybe I had said, "Oh, CRA," thinking it's the filing. I don't even know. Anyways, I guess it's not that. The fully executed CRA states that reference is made to that certain actor agreement. Uh, there are no discussions or other materials in the record shining any light on that edit. The edit cannot be read as evincing the parties' mutual intent to be bound by the then extant copy of the ALA. At the time the edit was made and the CRA was executed, Lively's counsel had not yet gotten back to It Ends With Us with its promised comments um, on the draft long form. Lively had not even suggested the changes of to the ALA that she now relies upon and that are at issue in this case, those over SH. So to recap mid thought or whatever, she added, correct me if I'm wrong, the contract said nothing about sexual harassment at all in any way. They started filming. She withheld signature and agreeing to the contract and withheld and withheld and withheld. They started filming. She kept withholding. They paused. They came back. She put in, she was like, oh, besides like the 17 points, like, oh, I want to make changes to the contract, to my contract, negotiate, trying to negotiate, like, I need um a point specifically about sexual harassment, and therefore she's suing now based on her proposed edits of her contract, not employment contract, but like contract for her services. And because the court is seeing the ALA not actually executed, because it ends with us said this will only be binding for all of us if it's executed and signed by her, Blakeo and Blake herself. Um, and they continuously rejected her addition. That's a moot point. And also, like, doesn't that sound so suspicious, so freaking suspicious that she wanted to add specific points? Like, it sounds and it looks like, allegedly, my opinion, it looks like she had at that point wanted to do some retaliatory action towards It Ends With Us, Wayfair, whatever. It sounds like the wheels were in motion at that time. She's like, ooh, if I put this in the contract and then they agree and then I sign and then I can pull up the 17-point list, or I can do this, I can um, say whatever I want in the press. I can drag them however I want to drag them, but I'm protected because I already signed that contract. They already signed that contract. I signed that contract. They agree to my terms, and therefore they can't retaliate towards me, kind of thing. That's my understanding of what is being said in this. Correct me if I'm wrong. And also, like, my opinion of what it appears to be behind the scenes of what was happening with all of these changes and whatever. So now it also kind of makes sense why she wanted that contract signed. She wanted the contract that she proposed edits to signed, but not the one that didn't have these things that would help her in this case. And also before this case, in just saying and doing whatever in the press, and they could not defend themselves as a result, potentially. Because I don't know, I don't really know exactly what was being said, what was being um added by her team to the contract, to the ALA. So yeah, Lively had not even suggested that changes to the ALA that she now relies upon as issue in this case. And most the edits reflect, It Ends With Us hope and expectation that there would be an actor agreement, and that once there was such an agreement, the CRA would survive the execution of that agreement. Therefore, the parties continued to negotiate over the ALA's terms and to go back and forth over the issue of Lively's signature. It Ends With Us continues to demand that there be a final executed copy of the ALA before it was bound. And Lively declined to provide such a copy. There clearly was not an executed ALA at this time, at the time that CRA was signed. Ultimately, so they're like, well, the contract was the offer letter, and the contract is like the CRA, but not the ALA. Right? Am I understanding that right? Ultimately, Lively fails to confront what is the central dilemma in her claim. She contends that the ALA became binding on It Ends With Us at some point while the parties were still negotiating it, but she cannot pinpoint a time when the parties began to be bound by it or which version of the ALA they were bound to. The existence of a contract requires a mutual assent and intent to be bound. Unless both parties are bound, neither party is bound. Which draft of the ALA bound Lively? What is the version that lacked the sexual harassment provision? Um, was it the version that lacked that? At oral argument, Lively's counsel suggested that the LA became binding once the parties began performing under the agreement, which counsel stated was the beginning of filming in May 2023. But if that is so, it would mean that ALA became binding before the SH provision was even proposed. And if it became binding at some point later, at some later point, Lively cannot identify when exactly there was an agreement and what the agreement specified. The only conclusion that the undisputed facts would support is that the parties performed services pursuant to the offer letter. It is that document which Lively, through counsel, said that she would perform until such time that the long form is fully executed. So she even said that. And it is only that document under which it ends with us accepted her performance. In some, the contract drafts, in some, the contract drafts combined with the parties' other written communications and actions conclusively establish it ends with us intent not to be bound to the ALA prior to its execution. Absent such intent, the ALA was never validly formed. Lively's contract claims under that agreement must therefore be rejected. All right. I don't know how many down, how many to go. Waiver of the conditions precedent. In the alternative, it ends with us argues that what in the alternative? Sorry. Uh, argues that even if the ALA was validly formed, its terms provide that it ends with us obligations did not arise until Lively signed the agreement. Because that never happened, it ends with us contends that it cannot be held liable. Lively responds that it ends with us waive the condition that there be assigned and executed ALA before it ends with us was bound by its terms. Waiver is a cousin to contract formation. Contract formation goes to whether there was an enforceable agreement between the parties at all. Waiver goes to whether, assuming an enforceable agreement, it ends with us voluntarily and knowingly abandon the terms that it would not be bound until Lively delivered final executed copies of the ALA. It ends with us agreements on this front succeeded for largely the same reasons that its arguments above do. California law defines conditions precedent as a contract term that is to be performed before some right dependent thereon accrues or some act dependent thereon is performed. Such a term may be waived by the party it is intended such a party may be waived by the party it is intended to benefit. The waiver may be either expressed based on the words of the waiving party or implied based on the conduct that is so inconsistent with an intent to enforce the right as to induce a reasonable belief that such right has been relinquished. In all instances, the pivotal issue is the intention of the party who allegedly relinquished the known legal rights. I'm just gonna on here. Ivory was not in identified has not identified evidence to support that it ends with us intentionally waived the conditions precedent under the ALA. With respect to its waiver, Lively can only point to Heath's May 3rd email in which he stated, "We have withdrawn our request for your client to sign her agreement in order to extend the time with the edit." But as previously explained, Lively takes this email out of context. It does not demonstrate a complete and total waiver of the execution conditions, but only a temporary acknowledgement of Lively's ability to continue with the edit while negotiations were ongoing. It is undisputed that it ends with us continued asking for Lively to execute the contract after that point, and that she declined to do so. As for implied waiver, neither it ends with us conduct nor its words were so inconsistent with an intent to enforce the execution conditions as to raise the prospect of a purposeful abandonment of those rights. When Lively's counsel attempted to strike the conditions precedent from the ALA on the grounds that they had been waived in practice. And it ends with us responded that the conditions still needed to be left in. That response did not implicitly concede that it ends with us had abandoned its rights under the conditions. It ends with us insistence on keeping the provisions in the agreement establishes just the opposite. Furthermore, insofar as Lively's counsels suggested that the conditions had been waived by the ends with us performance under the ALA, why does it keep doing that? Skipping that. That contention failed to account for the fact that Lively herself indicated that she would proceed in reliance upon the terms of the negotiated deal memo, that is the offer letter, until such time that the long form is fully executed. The only contract that it ends with us could be deemed to have accepted in practice was the offer letter. And her suggestion that it ends with us payment to her under the LA proves it ends with it. Well, we already read this. Okay. An oral agreement, Lively's counsel also suggested that it ends with us waive the conditions precedent by bringing suit against Lively under the agreement. But even accepting as true that it ends with us was suing under the ALA as opposed to the offer letter, the conditions precedent in the agreement specify that it ends with us obligations, not Lively's, were contingent upon Lively's signing of the contract. Thus, it ends with us lawsuit was in no way inconsistent with any intent on it ends with us behalf to enforce the conditions under precedent in the LA. The provisions went only one way. Lively therefore fails to present evidence that would demonstrate intentional relinquishment of it ends with us rights under the ALA. It ends with us cannot be held liable under the agreement, even if it was validly formed. And that sounds like she can, because she didn't say, right? Maybe not. Notice and cure. It ends with us offers one last reason as why Lively's ALA claims must be rejected. It argues that there was no actionable breach of the agreement because Lively did not satisfy ALA's notice and cure provision. The court agrees with it ends with us here too. Again, so wonderful to have like a human sentence there in short. Section 4.3 of LAE standard terms is entitled Company's Breach. It provides that no act of omission of company hereunder shall constitute an event of default or breach of this agreement unless artist shall first notify company in writing setting forth such alleged breach or default, and company shall not cure the same within 30 days after receipt of such notice. The ALA further provides that all notices required hereunder shall be in writing and addressed. It ends with us under the attention of Jamie Heath. It ends with us asserts that Lively never provided the requisite notice and opportunity to cure before asserting her breach of contract claims because the cease and desist letter she sent on December 20, 2024 was not addressed to It Ends With Us and did not mention any alleged breach of the ALA. It Ends With Us further argues that even putting aside the fact that the letter was not sent to It Ends With Us and did not assert a breach of the ALA, Lively failed to comply with the contractual 30-day cure period by filing suit only 11 days after sending the cease and desist letter. Lively responds that It Ends With Us waived this defense by failing to plead it as an affirmative defense in its answers. She also contends that she complied with the provision because It Ends With Us had notice of its breach at least by December 31st, 2025, even when she filed suit in this case. And two, she filed her first and second amended complaints on February 18th and July 30th outside the 30-day window, thereby mooting any issue regarding It Ends With Us having an insufficient opportunity to cure. I love when I catch my parakeets like drinking water because you never see them. It just, you see it kind of changing, but like you never see them. Oh, Julius. Lively's first agreement lacks merit because her failure to comply with the notice and cure provision in this context is not an affirmative defense. Under the terms of the ALA, notice and cure goes to an element of a claim for breach of contract which the plaintiff and not the defendant must satisfy to prevail on her claim. The elements of a breach of contract claim under California law are: one, existence of the contract, which was deemed not; two, plaintiff's performance or excuse for non performance; three, defendant's breach; and four, the resulting damages to the plaintiff. The plaintiff in a breach of contract action bears the burden on each element. So she bears the burden. As a general matter, a notice and cure provision can implicate both the second and third prongs. With respect to the second element, courts have held that notice and opportunity to cure is an element of performance that the plaintiff must satisfy before bringing a claim for breach of contract. Plaintiff's written notice was an essential element of its breach. Blah, blah. With respect to the third, where the contract expressly provides that no act or omission shall constitute a breach absent compliance with the notice and cure provision, a breach cannot be shown without demonstrating that notice and an or have been provided. Why do I keep like, I don't know. It's like dry throat, not dry mouth, but dry throat. The California Court of Appeals decision in this other case is instructive. That case is complicated in many aspects, but involves a relatively straightforward contract claim. In short, the developer of a ranch entered into a contract with the county whereby the developer agreed to dedicate land as a permanent open space and contribute funds for cleanup, restorations, and enhancement of the space on the conditions that the county agreed not to appeal or litigate the developer's plans for a project site. The agreement further provided that the county, this is another case explaining another case that is instructional, was it said? The county would indemnify the developer from any and all liabilities or expenses, including attorney's fees caused by the county's breach of the agreement. The county subsequently initiated suit, and the developer thereafter argued breach and sought fees under the agreement. The district court granted the developer's motion after finding that the county breached the agreement by filing suit. The Court of Appeal reversed, concluding that the trial court's ruling that the county breached the agreement was erroneous because the agreement expressly defines a breach as the failure to cure an alleged breach. Oh my gosh. This is so annoying. Of proper notice of the alleged breach and the developer failure to give the county proper notice of breach. Much like the agreement here, the contract in Silverado stated that a party shall be deemed in breach of this agreement only upon the failure to perform any obligation under the agreement after receipt of written notice of breach and failure to cure such breach within 30 days. The court noted that the agreement did not simply require that a party give notice of breach as a prerequisite of bringing. So just notifying is not the thing, but also giving that 30 days people notified to cure it, to like resolve it, to whatever. Okay, so the same conclusion applies here, that ultimately the court summarized, because the agreement unambiguously provided the county shall be deemed breach of the agreement only upon its failure to perform any obligation under the agreement after receipt of written notice of breach and failure to cure the breach within 30 days. The trial court erred in ruling the county breached the agreement, and the developer was therefore entitled to recover attorney fees under the agreement. So the same conclusion applies here. The ALA expressly defines company's breach as arising only where Lively first notifies It Ends With Us of the alleged breach and provides 30 days from receipt of that notice to cure. This unambiguous language means that there can be no findings of breach, a necessary element of Lively's case, unless she first establishes compliance with the notice and cure provision. Because it is Lively who bears the burden of demonstrating It Ends With Us breach, It Ends With Us did not need to specifically identify the notice and cure provision as an affirmative defense in its answer. It therefore did not waive reliance on the provision by failing to do so. To be sure, the plaintiff need not always plead and prove compliance with a notice and cure provision. It depends on the terms of the relevant agreement. If the agreement were to provide only that the plaintiff could not initiate suit until it provided notice and an opportunity to cure, notice and cure would be a condition to bringing suit, but not a prerequisite to showing breach. Um, but to reiterate, such an agreement is not at issue here, as the ALA requires notice of an alleged breach and expressly states that no act shall constitute an event of default or breach. How many times did I say breach? Because it sounds like I've said it way too many times, and it's like I hear it extra. Absent compliance with the notice and cure provision. Accordingly, the provision of notice and cure goes does go directly to whether Lively can establish breach. Little drinking game moment, as an element of her prima facie case. I don't know. The relevant state's laws also matter. The court has previously explained that under the federal rules of civil procedure, whether a plaintiff or a defendant bears the burden of pleading satisfaction of a notice and cure provision is determined by the elements of state law. As elucidated in Silverado, California law requires plaintiffs to establish compliance with clear and unambiguous notice and cure provisions where the provision define breach around notice and cure principles. Other states might allocate the burdens differently. The court therefore turns to whether Lively satisfies the notice and cure provision in the ALA. She did not. In her summary judgment papers, she points to no notice that she sent and addressed to It Ends With Us, which specifically raised the specter of breach of the ALA. The November 9, 2023 email sharing the protections for return to production made no mention of breach of any agreement, which makes sense given the ALA had not been executed, and the offer letter contained no terms regarding SH or retaliation. December 2024 cease and desist letter was not addressed to It Ends With Us and therefore plainly failed to comply with ALA's specified notice procedures, which required a writing addressed to It Ends With Us under the attention of Jamie Heath, setting forth the specific language alleged breach. Lively did amend her CRD complaint on December 30th to name It Ends With Us, but simply amending her complaint again failed to comply strictly with the ALA's notice procedures. Lively also initiated the suit the very next day, depriving It Ends With Us of its 30 days opportunity to cure. Lively suggests that any issues regarding the cure window are now moot because her first and second amended complaints were filed more than 30 days after the suit was initially filed. Therefore 30 days after It Ends With Us had notice. But Lively's amended complaint simply alleged the same breach of contract claim alleged in her initial complaint. Courts have repeatedly explained that the purpose of notice and cure provisions is to provide the breaching party an opportunity to cure that breach before litigation or termination of the contract. She didn't want that. She wanted a spectacle, allegedly, my opinion. As Ninth Circuit has explained, this purpose would be completely undermined if it could be satisfied with the giving of post-suit notice. In sum, Lively had has failed to raise a triable issue regarding it ends with us breach under the relevant contractual language given her non-compliance with the ALA's notice and cure provisions. Summary judgment is therefore warranted on this claim for an additional reason. The CRA is enforceable. Lively's attempts to enforce the CRA, and in particular its provisions specifying that there shall be no retaliation of any kind against the artists for raising concerns about the conduct described in this letter, stand on firmer ground. It ends with us makes two primary arguments why Lively cannot enforce the CRA. It argues that the CRA was not binding because it made reference to the ALA and there, thus had no force prior to ALA's adoption. Second, it ends with us argues that the CRA was not supported by consideration. Neither argument has merit. The court starts with it ends with us argument regarding consideration. Not actually Golden was talking about this, how she was seeing like, yeah, she can see why this is not out, and based on what we have so far, it's like it still stands to be proven or whatever. And yeah, they also like agreed to this to the CRA. So I wanted to say something else though. I'm like freezing. This is going to be tough during the summer. I don't know what I wanted to say. Anyways, one of the bedrock elements of contract formation, in addition, the manifestation of mutual assent, is oh, that's what I wanted to say actually earlier. The whole thing about no retaliation, in the way that I'm hearing all of that, those words was not after all of it has gone past and gone, but no retaliation on the set in the whole movie period of making that movie. So I'm curious about that argument too. But anyways, one of the bedrock elements of contract formation, and not saying that they even retaliated against her, and it seemed a bit opposite based on what I'm reading so far. One of the bedrock elements of contract formation, in addition the manifestation of mutual assent, is the exchange of bargained for consideration. Consideration is often defined as some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment. Wow, Arena. Detriment, loss, or responsibility given, suffered, or undertaken by the other. Consideration, blah, blah. It is well established that the slightest consideration is sufficient to support the most onerous obligation, and that the courts are not to inquire into the adequacy of consideration. Although courts will not second guess the fairness of an agreement or require equivalence in the value exchanged, there must still be something of real value in the eye of the law that both parties agree to give up. If a promise is so insubstantial as to impose no obligation at all on the promiser, who says, in effect, I will if I want to, then that promise may be characterized as an illusory promise, i.e., a promise in form but not in substance, and it will not constitute consideration. A written instrument is presumptive evidence of consideration under California law, but boilerplate recitals regarding the exchange of good and valuable consideration are not conclusive and may be overcome based on the facts and surrounding circumstances. Under California law, the presumption of consideration means that the burden of proof is on the party seeking to invalidate the agreement for lack of consideration, which may be accomplished through extrinsic evidence. The recital of consideration is a written instrument, not conclusive. Okay. New York contains no such codified, whatever, presumption regarding written agreements. It is instead black letter law that the burden of proving the existence, terms, and validity of a contract rests on the party seeking to enforce it. But as under California law, the words good and valuable consideration cannot serve as a consideration where the facts show that nothing good or valuable was actually given at the time the contract was made. A promise to perform a pre existing legal obligation cannot constitute new consideration, as such, a promise is not in any sense bargained for or given in exchange for a new counter promise. However, parties promise to perform a legal duty that is doubtful or the subject of an honest dispute can constitute consideration. Regardless of where the burden in this case falls, there is sufficient evidence in the record to conclude that the CRA was supported by valid consideration. In particular, when the parties entered into the CRA, Lively's legal duty to return to set for the second half of production was at least doubtful or subject to an honest dispute. Wait, I kind of zoned out on that one. Regardless of where the burden in this case falls, or burdens fall, there is sufficient evidence in the record to conclude that the CRA was supported by valid consideration. Oh, sorry. In particular, when the parties entered into the CRA, Lively's legal duty to return to set for the second half of production was at least doubtful or subject to honest dispute. Um, the offer letter, the only agreement by which she was bound to perform, required her to provide exclusive principal photography services for up to 6 consecutive weeks during the run of production. And filming paused 1 month into production due to Writers Guild of America and SAG-AFTRA. By its terms, the offer letter did not oblige Lively to commit to more than 6 consecutive weeks of principal photography. Her duty to continue with filming at that point on a different schedule than the one previously agreed to, that's so interesting, was therefore subject to at least some uncertainty. Her agreement to resolve that uncertainty by returning to set constituted valid consideration. That is what the CRA, in fact, recites. It states that the parties wish to confirm the conditions upon which Blake has agreed to cause Lively to render acting services on the film following the break in production of the film related to 2023 WGA and SAG-AFTRA labor strikes. So basically, like, her agreement reset, and so in after they were coming back, she's like, I have a new offer letter, I have a new agreement, I have a new contract, to propose, and that is null because it's been the consecutive weeks have not have gone and been. Okay. It ends with us also argues. Wait, did I say? The clear implication is that absent agreement to the conditions, Blakely would not cause Lively to return to set, and because it was unclear whether Blakely had an obligation to cause Lively to return on set and whether Lively herself had such an obligation, the CRA was supported by valid consideration and is binding. It ends with us also argues that the CRA is not enforceable because it makes reference to the ALA and the ALA was not executed. That argument has no greater merit. The CRA states that it shall be deemed incorporated into the ALA. The CRA also states that in the event of a conflict between the CRA and ALA, the terms of the CRA govern. Yeah. The interpretation of an ambiguous contract is a matter of the court. It is clear that the CRA does not make entry into the ALA a condition precedent to the execution of it or to the parties' obligations under it. As previously explained, a condition precedent is an act or event other than a lapse of time, which, unless the condition is excused, must occur before a duty to perform a promise in the agreement arises. The CRA sets forth a series of promises by it ends with us, none of which is conditional upon there being an ALA, and each of which is stated to confirm the condition upon which Lively would return to work. In context, the reference to the ALA means nothing more than that where the ALA to be executed, the CRA would be deemed incorporated into it and not superseded by it. In other words, the CRA contemplated the possibility that the parties would enter into the ALA, and it set forth how the CRA would apply in the event of that contingency. Yeah, it was not itself contingent upon the signing of the ALA. The parties' conduct confirms that understanding as they both performed under the CRA, notwithstanding continued negotiations over the ALA. The Wayfarer parties took steps to implement the CRA's requirement, including by hiring a new producer. Lively, for her part, returned to the set for the second phase of production. The CRA thus carried independent and binding force. Ends with Us argues that even if the CRA is enforceable, Lively's claim for breach of that agreement must be rejected. It Ends with Us again relies on the notice and cure provisions in the ALA, but no such provisions appear in the CRA. Of course, where there are multiple integrated agreements, those agreements are to be read as unified whole, but here there is only one agreement, the CRA, because Lively never agreed to the ALA. She cannot be deemed to be bound by its terms. Indeed, as explained above, the intent of the parties in making references to the ALA was not to incorporate all of its terms, including the conditions, precedent, and notice and cure provision, but to ensure that if the ALA were ever adopted, it would not supplant or supersede the CRA. In order, the parties did not assent to the incorporated terms and did not affect wholesale adoption of the ALA through the back door of the CRA, nor did they evidence an intent to carry over any of its specific provisions. All right. Oh, this is interesting. It Ends with Us also argues that Lively's claim under the CRA fails because she cannot prove damages. It Ends with Us makes four arguments in this respect. Lively cannot recover consequential damages, or what California law calls special damages, under the limitation on damages clause in the ALA. Lively cannot recover emotional distress damages for breach of contract, and Lively's alleged contract damages are improperly duplicative of her alleged statutory damages. And another one. Four, Lively cannot recover damages for the lost profits or royalties of two entities she controls, Blake Brown Beauty and Betty B Holdings LLC, for lack of standing and because such damages are speculative. None of these provides a basis for granting judgment on Lively CRA claim. To begin, words to be dreaded when reading such a thing. To begin, the Wayfarer parties argue that nearly all of Lively's asserted damages are consequential or special damages, and that such damages are barred by a provision in the ALA stating that in no event will any party hereto be liable for or have any obligation to pay the other consequential and or incidental and or special and or punitive damages. So now they want the ALA to be taken into consideration. This argument fails for the same reason that the notice and cure argument above fails. No analogous provisions appear in the CRA. The parties never agreed to the ALA. They are bound. They are not bound by it. Second, It Ends with Us argues that under California law, a party cannot recover damages for emotional distress, including distress from loss of reputation as a result of breach of contract. There may be some question with respect to the reach of that doctrine and its applicability here. The court need not reach that issue, however, as Lively does not her opposition to summary judgment on the basis that she is solely entitled to damages for emotional distress and loss of reputation. Third, it ends with us argues that Lively's contract claim is improperly duplicative because she seeks recovery for the same damages under her statutory cause of action. The case that it ends with us cites, however, stands for the proposition that if a plaintiff proceeds on two claims, each of which seek damages for the same injury, the plaintiff will not be entitled to double recovery. Lively statutory and contractual retaliation claims will present their separate challenges at trial. Lively need to forego one theory of recovery at this stage in order to pursue the other. Finally, it ends with us argue. Oh, so okay. It ends with us argues that Lively cannot recover for lost profits to Blake Brown Beauty and Betty B Holdings. Lively responds that she is not seeking relief in her capacity as a shareholder, but rather direct damages to her own business reputation in connection with her own legal claims. The court I mean, this is kind of like saying, you know, if I do a commercial, right? For something, if I'm like the spokesperson, like the one lady for Progressive, like she Flo is her saying, well, because she was in some scandal or something, she's entitled to damages based on that, or Progressive is entitled to damages because of that. And I mean, unless it's in the contract, I don't see why. Lively responds that she's not seeking relief that way. The court has the authority under Rule 56G to determine a fact that is not genuinely in dispute, including an item of damages. The court can decide that it is better to leave the matter for trial. In this case, the parties devote only a few pages to Lively's theory of damages. The issue is better addressed at trial or prior to trial through motions in limine directed to the admissibility of evidence and argument. It ends with us motion for summary judgment with respect to Lively's contract claim under the CRA is denied. Lively's, so I take that back about like her damages regarding to that. Okay. Lively's first and second causes of, where am I? I'm like, okay, 100 pages to go. I will not finish those today. Lively's causes of action alleged harassment and retaliation in violation of Title VII of the Civil Rights Act of 1964. Her fifth cause of action alleges retaliation in violation of California Labor Code Section 1102.5. The Wayfair parties raised the threshold issue of whether the laws cover Lively in the first place. How long is this? Okay, that's not long. All right. Lively's first and second cause of action alleged harassment and retaliation in violation of Title. Okay, I just read that, didn't I? Yes, I did. Under both California and federal law, the question whether an individual worker should properly be classified as an employee or instead as an independent contractor has considerable significance for workers, businesses, and the public generally. It appears that a prerequisite to asserting a violation of Labor Code Section 1102.5 is the existence of an employer-employee relationship at the time the allegedly retaliatory action occurred. Lively sexual harassment and retaliation claims under these provisions can therefore proceed only if she was an employee rather than an independent contractor. The court will assess Lively's employment status under Title VII and California Labor Code Section 1102.5 in turn. Legal background. Do I have to? Do I have to? And I also really need to go to the bathroom. Okay. Title VII covers employees, but the statute's definition of that term is circular. The act states that, or only that, an employee is an individual employed by an employer. In determining whether a person is an employee for purpose of Title VII, courts have applied the analysis derived from the Supreme Court's decision in Community for Creative Nonviolence versus Reed, a case involving the Copyright Act, and Nationwide Mutual Insurance Company versus Darden, a case involving the Employee Retirement Income Security Act. The relevant factors are drawn from the general common law of agency rather than from any particular state law, given the federal state statutes are generally intended to have uniform nationwide application. In particular, the Supreme Court has outlined 13 factors drawn from the restatement of agency and from case law. I swear I read that as coleslaw because it's lunchtime ish. Um, yes, yeah, but it's case law, not coleslaw. Um, that courts are to consider in determining whether a person is an employee. In determining whether a hired party is an employee under the general common law of agency, we consider the hiring party's right to control the manner and means by which the product is accomplished. Among other factors relevant to this inquiry are the skill required, the source of instrumentalities and tools, the location of the work, the duration of the relationship between the parties, whether the hiring party has the right to assign additional projects to the hired party, the extent of the hired party's discretion over when and how long to work, the method of payment, the hired party's role in hiring and paying assistants, whether the work is part of the regular business or the hiring party, whether the hiring party is in business, the provision of employee benefits, and the treatment of the hired party. Balancing the Reed factors is a high fact specific task. No one factor is dispositive, and additional circumstances may be considered if they are drawn from the common law of agency that Reed seeks to synthesize. Courts must disregard those factors that, in light of the facts of a particular case, are irrelevant or of indeterminate weight. That is, those factors are are essentially in um, ooh, equipoise, and thus do not meaningfully cut in favor of either the core conclusion that the worker is an employee or the conclusion that he or she is an independent contractor. A court may determine that a plaintiff is an independent contractor if even if one or more of the Reed factors analyzed in isolation would suggest to the contrary. The analysis is not identified to congressional intent. A person who may be deemed an independent contractor for purposes of the work for hire provisions of Copyright Act, where the rights to intellectual property can depend on contractual terms, may nonetheless be an employee for purpose of Title VII, where Congress intended to create public law rights that were vested in workers as a class and not subject to waiver or sale by individuals. Thus, while factors such as employment benefits and tax treatment might deserve special consideration in the copyright work for hire context, where workers and employees or employers are free to allocate intellectual property rights by contract, those factors are entitled to less weight in the employment discrimination context, as firms could use individual employment contracts to opt out of anti discrimination statuses or statutes. Sorry. Statutes. As the Second Circuit explained in Eisenberg, the core substantive protections of the anti discrimination laws were not intended to be skirted by the terms of individual employment contracts. My parakeets are sleeping. I'm like, it's been quiet for a while. The most important factor in determining the existence of an employment relationship under Title VII is that control or right of control by the employer, which characterizes the relation of employer and employee and differentiates the employee or servant from the independent contractor. The degree employer control is the foundation for Title VII's limits. Independent contractors are thought to not to need Title VII protection because such contractors already have a degree of control over their employment, which is what not actually Golden was saying. The presence of or absence of each read factor raises a question of fact, but the ultimate determination as to whether a worker is employee or independent contractor, that is the balancing of read factors, is a question of law. If based on the undisputed facts, no reasonable jury could determine that the plaintiff was an employee, the court may not shirk from stating that conclusion. Um, oh my god, I'm lost. If the interference is clear, there is, but that there is, oh my gosh, it's clear that there is not a master and servant relation, the word usage, the determination is made by the court. Otherwise, the jury determines the questions after instruction by the court as to the matters of fact to be considered. Blah 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 blah. Okay. Factual background: the parties dispute the existence of certain read factors and the extent to which they either weigh in favor or against a finding employment status. However, they do not dispute the underlying material facts. Lively agreed with It Ends With Us movie, a company formed to produce a single film that form a specified role in the film based upon a pre-agreed script with a pre-agreed director and a pre-agreed co-lead. The offer between It Ends With Us and Lively's loan out entity, pursuant to which Lively performed and was bound, gave Lively important rights both with respect to the film and her participation in it. No change could be made to the script, the director, the co-lead, or the double, if any, for Lively without her permission. Lively had rights with respect to her hair and makeup. Blah 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 blah. Artists will have mutual approval rights over the following: hair, makeup, wardrobe personnel, stand-in, stunt double, if any, the screenplay, director with Justin Baldoni pre-approved, and any replacement, and the co-lead for the picture with Justin Baldoni pre-approved, and any replacement thereof. Meaningful consultation over the look of the role, ad campaign and release pattern. Hair makeup personnel are exclusive to artists. Peter Owen is pre-approved as wig maker, so like no one else could use it. Damn. Okay. I have to change laundry again. The offer letter contains additional approval provisions, including Lively's right to sign off on the filming start date in May 2023, any shoot days outside New York, New Jersey, or New York, her transportation for such shoots, the trailer provided for her on set, use of her name, voice, or likeness in merchandise, commercial tie-ins, co-promotions, and the like. Outtakes and behind the scenes shooting and the use of any such footage, press and EPK crew on set, interviews, press releases, and statements, use of nudity and or simulated sex in the film, and digitizing or doubling of Lively in any such scenes, doubling of Lively in the film more generally, and use of clips for the film. There is no genuine dispute that Lively's approval rights were honored in practice. Lively's counsel acknowledged at oral argument that there was nothing in the record indicating that Wayfair parties ever ignored, refused, or rejected Lively's exercise of her approval rights under the offer letter. There also is no genuine dispute that Lively had extensive involvement in and control over many of the decisions related to the film and her role. She does not dispute the underlying facts relayed in her letter to the Producers Guild of America. As reflected in that letter, Lively said, led the location shift from Boston to New Jersey and helped. That's where I heard that. blah, 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 and helped to solve all cost and schedule logistics associated. Personally called and or wrote emails to crew and put forth names for department head roles and identified and onboarded freelance team members of the cast members, which all of this was really um kind of sounding like they were partners rather than employer employee. Not that partners can, SH each other and stuff, but like, yeah. Lively does the suggestion that she ultimately unilaterally caused the assistant director to be terminated, stating that it was instead done on producer Alex's recommendation due to performance deficiencies. How convenient. The difference is immaterial to the disposition of these notions. Blah, 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 blah. There also is no dispute that in addition to a flat sum guaranteed as payment for her work on the film, Lively was entitled to contingent compensation based on film's performance, as well as compensation in the form of credit and bonuses for awards. Oh, that's a thing. Wow, okay. Oh, that puts things into a new light that people are like given bonuses if they win different awards. Sometimes the offer letter committed Lively to providing 6 weeks of exclusive principal photography services plus standard prep services, subject to her approval and availability, and up to 3 free post days. At any other point, Lively was free to accept other work and to perform in other films, which she did. The PGA letter indicated that she was shooting another film while simultaneously working a minimum of 10 hours a day on post production for the film. As for her working hours during principal photography, the offer letter uh, cabined them as follows: 12-hour portal to portal, 10.5-hour portal to portal, drop off at home until pickup and at home the following day. 56-hour portal to portal. We can turn around provided that artists will give good faith and consideration for reducing the weekend turnaround to 52 hours portal to portal, up to 2 times during principal photography, blah, 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 5 days, weeks, Monday through Friday, no more than one forced call without artist prior consent. Analysis. The undisputed facts reveal that Lively enjoyed a degree of economic independence sufficient to make her an independent contractor. Although not every factor weighs equally in favor of the conclusion when viewed in isolation, analyzing the factors collectively eliminates any genuine dispute. That means that Lively cannot bring a claim under Title VII. The court first analyzes each read factor separately, recognizing that they overlap and that certain undisputed facts are that are relevant to one factor may be relevant to others. Right to control. This factor favors independent contractor status. Lively enjoyed extensive control over the means and manner by which the product was produced, both as a matter of contract and in practice. The type of comprehensive control that characterizes a traditional employer employee relationship was absent here. Let's just go to the next one. Where is it? What? So wait, I thought this was going to be. Oh. By contrast, it ends with us produce only one product with Lively's participation in the film, for which her approval of the script, director, and co-lead was required before she was bound. Moreover, and thus could not make any changes to those aspects of the production without her approval. She had the right to meaningful consultation, not just over the look of her role, but also over the ad campaign and release pattern. Um, Her name, voice, likeness, etc. Um, could not be used without her consent, basically. Theme park attraction. She had the right to approve any behind the scenes shooting and any use of the footage, any outtakes, the press or and crew on set, in any interviews. It ends with us could not issue a first press release mentioning her as an actor without her approval and could not issue any additional press releases mentioning her other than as an actor of the film without her approval. She had control over her hair and makeup, and the Wayfarer parties did not have the right to cast an actor as her double without her prior written consent. Lively had also had power as a matter of day-to-day reality of the parties' working relationship. Lively described Baldoni in the PJE letter not as an employer, boss, or superior, but as a partner in all creative and logistical concerns. It is undisputed that, among other things, she reviewed and reshaped the production and costume design for all key locations and characters, performed significant rewrites of the script to incorporate feedback from the cast, studio, distributor, author, director, reviewed and instated COVID-19 protocols, led meetings with all department heads, the studio, and the distributor, oversaw a team of editors, and coordinated and managed cast and crew's various schedules for film's press release. Lively emphasized that the Wayfarer parties had the right to control her performance because she had to render her acting services when and where they directed. Specifically, she states that she had to adhere to a set work schedule and provide exclusive services during filming, but these factors weigh only marginally, if at all, in favor of her being an employee. The duration of her work on the film and the start date on which that work began were heavily negotiated. Just as she was required to start in May 2023 and to continue for up to 6 consecutive weeks during the run of production, so too if it ends with us wanting to make the film with her, was it ends with us required to adhere to that schedule. Moreover, that Lively's time commitment was defined by the task at hand, the run of production, with a maximum number of weeks during which she could be required to work, further suggests that she was not an employee. Lively was hired only for a particular project. It had no right to any of her time beyond what was necessary to accomplish that project and what was outlined in the offer letter, blah, blah, blah. I'm going to kind of stop here and pick it up later. Man. Wow. I feel like this is like the bulk of it, this read parts. Yeah. All right. So was it page 53, 63, 60 something? Something like that. I'm gonna pause and stop and resume maybe or something. I don't know. I'm curious about this now. But I also need to attend to bathroom, food, and this was my day off, like my completely off day, because tomorrow I have rehearsals. I'm doing a play, and then Sunday is a whole number of things. So yeah, I will come back. Thank you for those watching this retrospectively. Is that a word? I don't know. I can't think right now. Or live. And I'll see you guys soon. Let me stop the sharing. Yep. So yeah, cool. I will talk to you guys soon. See you soon. This is an interesting development, to say the least. Peace, love, and compassion until then. Bye.